Good morning, good afternoon to everyone, and thank you for your time for attending our webinar today after a long slowdown period, actually. Today, we will again discuss about the sanctions and the recent enforcements together with my colleague, Bradley Henry. Henry is a counsel from Blank Rome. Henry, would you please introduce yourself to the audience?
Hi, everyone. I'm Brad Henry. I'm a partner in the white collar defense and investigations practice at Blank Rome. Blank Rome is a top 100 American law firm. I am in the New York office. My practice focuses on sanctions, anti-money laundering, and anti-corruption work and compliance all over the world. It's a pleasure to be here with you, Shafik. Thank you.
Great. Thank you, Brad. There have been a lot of developments during the summertime, and I want to ask you to start with asking the question of what are some of the most significant recent changes in sanctions enforcement and how they are impacting the global compliance strategies, Brad?
Sure. Yeah, so the first thing I think that we're noticing in relation to the sanctions today is just the sheer number of designations that are happening. Very large batch designations you will have seen last week, and about a month before that, you get 300 or 400 companies, individuals, or others who are designated primarily under the Russian sanctions regime because of the hostilities of the Russian Federation in Ukraine. And so you're seeing more and more of those kinds of things, but you're also seeing those in sectors like the Iranian origin LPG space. And in many cases, they're sanctioning or designating people with no forewarning or heads up. They're not being in communication with you before you end up on a sanctions list. And so and with people that we represent and or are talking to, often it comes as a total surprise. And it's being based off of U.S. intelligence or other classified information from the U.S. government. The State Department has gotten more heavily involved as well. It's important to keep in mind that once you're sanctioned, of course, it takes a lot of time and effort to wind out of that. And so, making sure that that you have compliance programs and capabilities on the front end is very important. A few other observations. First of all, there are increasing penalties and an increasing number of enforcement actions that are happening. You'll see that in addition to the designations, they are actually settling cases. OFAC is settling cases. BIS is settling cases. We'll talk about a few of those in just a few minutes. But the penalties are becoming heavier and heavier. For example, in 2023, OFAC assessed over $1.5 billion in penalties across 17 resolutions. And that's the highest ever in a single year, even if you look back to when they were having the huge, bank settlements. That those are hefty penalties across multiple actions. That includes record settlements with Binance Holdings, which is a crypto company, and also British American Tobacco, which, if you'll recall, was related to North Korea tobacco sanctions. And then the other thing that you're seeing a lot of is enhanced interagency collaboration. OFAC working with BIS. You will see these tri-seal advisory notices going out from Treasury, from BIS, and also from the State Department that talk about their focus when they are looking at sanctions and export control violations. So there's been a lot of increased cooperation and a focus on that. Obviously the aim of that is to tackle sanctions evasion and export control more effectively, which I think the U.S. government in particular is really working on improving their capabilities in the enforcement space. So I think we'll see more of that. There are more resources being thrown at it. They're hiring prosecutors. I think they've hired over 10 prosecutors at DOJ that focus solely on sanctions. I think the aim is to get to 25, and they're on their way to doing that. And so, that's a huge pouring in of resources for that. They're focusing more on technology. I think that's something else that you need to be looking out for, not only in the sanction space, but in the export control space. I think they're really trying to ratchet down on technology, especially technology that can be used for military purpose in relation to the Russia sanctions. And then there have been a lot of organizational changes in OFAC itself. And one of those is that they've consolidated their investigations and enforcement capabilities under a single enforcement division. So that'll help them coordinate and stay on track across their multiple enforcement actions, which I think will result in an increased number of settlements that you'll see coming in the future. One other important note, and this will directly affect the way that you do your compliance, is that the statute of limitations for sanctions violations in the U.S. has recently been increased from 5 years to 10 years. And that's important to note because previously when you had compliance programs, some companies would decide to get rid of their, documents or, purge the system to keep from having too many documents around, not necessarily to avoid having the documents, but for document maintenance, which is pretty standard. But now you're going to have to keep those documents for much longer, twice the period of time, which also gives the government a lot of time to look into actions, gives them more leeway. And so as a result of that, you'll see a lot more actions coming out of that because of the increased time that they have to investigate and bring cases.
Mm-hmm. Brett, how do you anticipate the sanctions enforcement evolving in the next year, and what should the organizations do now to prepare?
Well, first of all, I think this goes a little bit into my prior question, but it's important to note that here in the U.S., we're coming up on an election where it's very heavily contested. I think the thing to take away from that in the sanction space is that sanctions are bipartisan, right? Democrats and Republicans in the U.S. use sanctions heavily. They, over the course of the last 10 years, have been used more and more as a national security tool. And I think we'll continue to see that regardless of whether Donald Trump or Kamala Harris win the election, they will use sanctions to advance their foreign policy. And so I don't think you'll really see any backing up of that. That's a question we get a lot. The government's going to continue to focus on sanctions violations, and I expect myself to see more criminal cases coming, especially against individuals, but I think we may also see some coming against companies. What we've seen the most of so far is really criminal cases against individuals who the U.S. government's really probably never going to get their hands on. It's really just to show, the capability to bring those actions, but because of extradition and where some of those people are located, it's unlikely that many of them will ever end up in U.S. custody. But I think you'll see more of those kinds of cases start to filter through where they are able to arrest and prosecute individuals. But you're also going to see companies in the worst case scenarios who are being prosecuted for bad acts. And so that's something to keep an eye on. Again, an increased focus on technology and cybersecurity. Those are very important now for the U.S. government, particularly in the China space and the Russia space. So those are two things to keep an eye on. The government's going to continue to focus heavily on that. There's going to be enhanced multilateral cooperation. You're going to see more enforcement actions coming not only from the U.S., but the UK government, the EU government, as the UK and the EU and OFSI and those programs begin to get more resources and more experience, they will start to bring more and more cases. And so you'll see the US government, the UK government, the EU government, maybe others, start to begin to work together more and more to bring actions sort of across jurisdictions. There's going to be an expansion of thematic sanctions programs, really things, like targeting human rights abuses, corruption, environmental crimes. I think those things are things that we're going to see start to grow in the near future as they start to get a hold of the Russia sanctions and sort of they were drinking out of a fire hose for a long time, but I think they're starting to catch up a bit.
Yeah.
They're going to start to use advanced AI and analytics technology to try to track these cases more quickly. And then again, like we said earlier, there's going to be increased penalties and publicity about cases to try to deter others from doing the same sorts of things. And I think it's worth noting just a couple of cases, and we'll get into what that means for your compliance function in just a second. But for recent settlements were State Street Bank, which is a U.S. company in Charles River. The Charles River settlement is worth reading. If you are a company or a general counsel or a compliance officer at a company in Turkey or anywhere else, you want to read the Charles River settlement. It is just a roadmap to what your sanctions program should look like, and it will give you a lot of information. So I would suggest that. There was Mondo TV, SPA, SCG Plastics, and EFG International. What you'll notice from those four recent settlements is that they are across a broad range of companies. There's financial institutions, there's Russia sanctions, there's crypto. You're going to see that there are going to be a variety of types of cases they're going to go after. Gone are the days where they are just focusing on financial institutions or certain business sectors. They are now looking at cases sort of across the board. The penalties in those cases are very high. Particularly State Street and Charles River was a significant fine. You're going to see that they're going to start trying to extract, huge penalties out of people, just again for deterrence purposes. They are going to continue their focus on financial institutions. I think particularly in the crypto or digital asset space, more importantly, but also traditional financial institutions and payment services companies, and that's going to be not only across sanctions but probably across their AML function as well. What you'll notice from those four is that two of those were against non-U.S. entities. Mondo TV and SCG Plastics are non-U.S. companies, and so you're going to see a lot more actions going after non-U.S. companies, which for folks in Turkey and the region is really important to keep in mind. I think there's been a lot of talk about in relation to many different things, but you're going to see more focus on foreign companies, and so that's important to keep in mind. And then they want, they're going to have enhanced compliance expectations, and so you have to prepare as a company to meet these challenges ahead of time. You should be preparing for all of these things that we're going to see in the future. And so some ways that you can start to do that is to start strengthening your due diligence program. Who are your customers? Who are you dealing with? Who are you selling to? Where are you getting supplied from? That cuts across all of your AML sanctions and anti-corruption compliances. You got to know who you're dealing with. And so it's important to continue to focus on that. You're going to want to start thinking about investing in technology. We'll talk about this more in a little bit, but the use of analytics and AI and the ability to gather data across your company can really be useful in combating these sanctions violations and other types of violations. And so that's something you're going to want to be focusing on in your compliance function. You're going to want to stay informed. These things are changing more quickly than they ever have before, and before they changed a lot. So you're going to have to stay on top of things, continue to monitor OFAC designations, continue to monitor designations from other countries, but also be read up on what's happening sort of across your company, your region, and really across the globe. And then the other two things that are critically important in any compliance program, but you're going to want to continue to focus on these, is more training for employees. As things change, training needs to keep up with that, and internal audits. You want to make sure that things are running smoothly, that you are catching things when they're supposed to be caught, that your systems are working, and that if there need to be changes, that you can make them quickly and efficiently.
What I observe in the market is that, especially for the new practitioners, for the sanctions and the export control issues, that they are confused of the expectations of OFAC and BIS. So in what ways do the compliance expectations of OFAC and BIS differ, and how can organizations effectively manage these differences?
Yeah, sure. So, I mean, that's an important designation, right? Because first you have to understand that OFAC and BIS have very distinct but complementary roles in enforcing U.S. sanctions and export control regulations. If you look at OFAC and Treasury, they are focused on economic sanctions, right? Doing or not doing certain things with financial transactions. BIS, on the other hand, is really concerned with the export of goods and technology from the U.S. or a country, from the U.S. to another country. And so there are key differences in their compliance expectations and how organizations can manage those differences. The first thing I want to note is don't wait until you're designated. One of my good friends in Turkey, who many of you probably know, has a great saying, which is, if you think compliance is expensive, wait until you have to pay for non-compliance, right? And that's always really rung true with me. It's invest early, make sure you're doing the things on the front end to protect your company, and really buy into the system, because on the back end it will really save you a lot of headache, because it's nearly impossible and it's super expensive to build out a compliance program after the fact. And so, be thinking about that. And then, as noted before, with recent actions, we see an increased attention towards foreign companies. I mentioned earlier that there was a whistleblower program that just launched in the U.S. That covers a sort of a scope of issues, but one of them, of course, is sanctions violations. And what it really does is it gives employees at companies the opportunity to report to the U.S. government directly without having reported to their company that they, see there is some wrongdoing going on. And that kicks in to affect a number of issues, including a very short timeline in which to investigate and then, quote, self-report to avoid enhanced penalties. It's 120 days, which, for all of you who have done investigations, know that is a very fast timeline on any, remotely complicated investigation. And so you'll want to have those systems in place early. You also want to incentivize your employees to make sure that they are talking about those things. So, making sure that you understand the difference between a sanctions violation and an export control violation. Who do you report that conduct to? How is that information taken and processed? And then, being able to deal with that in the appropriate way. Going back to your question, Shafak, about what ways do compliance expectations between OFAC and BIS differ? So first of all, going back again to the scope of the authority for OFAC versus BIS, OFAC focusing on enforcing economic and trade sanctions against targeted countries, regimes, individuals, and entities. So it's an outward-facing sort of program where they're looking to prevent third parties from receiving or being involved in transactions that benefit them for some policy reason. However, BIS focuses on regulating export, re-export, and transfer of commercial goods, hard goods, dual-use items, technology, software, widgets, whatever. And so they're really focused on what you have that you are providing to someone. The regulatory framework is different for both. OFAC gets its authority under various statutes, including the IEEPA and TWIA, which is the Trading with the Enemies Act, which is a very old act. And so the way that they are regulated are under those statutes, and there are very specific laws and rules related to those, whereas BIS functions under the ECRA, which is the Export Control Reform Act. And then they are controlled really by the EAR, which is a set of regulations called the Export Administrative Regulations. And so they derive their authority from different areas in law under the U.S. Code. And so that's something to keep in mind if you're looking, to prevent something in the sanction space. You'll want to look to those laws. If you want to learn about BIS and what they're controlling, you'll want to look at the others. And then compliance focus. OFAC, you'll hear this word a lot and probably know it by heart if you are in the compliance space, but risk-based approach to sanctions compliance is really important to OFAC. What that means is really focusing on those areas of risk that you've identified and paying a lot of attention to those and really trying to figure out where your pain points are and address them. BIS, on the other hand, doesn't really have a risk-based approach sort of philosophy, although I guess you could apply it. But really what they're focusing on is ensuring organizations comply with their licensing requirements, that they maintain accurate documentation, and that they have internal controls that prevent unauthorized exports. So the way that you handle those is a little bit different. Managing the differences comes down to really 5 things. One, develop an integrated compliance program. While they are different, and while young practitioners who are not in this space or have not been in this space very long, it's easy to confuse the two because there is a significant amount of overlap. But it is important to understand that they are different. But you'll want to integrate your compliance programs. You can't have a separate BIS and sanctions program. They sort of have to layer on top of each other. And so as you're creating your controls, keep that in mind and try to find efficiencies in the way that you are gathering information for both purposes. You want to conduct a comprehensive risk assessment at the beginning of every project, understand where your pain points are, understand where you are going to run into trouble, understand what your product is, and then build in controls to help minimize the risk related to those types of conduct that your business is doing. Invest in training and awareness. Employees are your best and first line of defense. Make sure that they know what the problems are. Make sure they know where they're supposed to be looking. They will help your company and help you maintain your compliance. Leverage your technology. We're going to talk about this throughout this presentation. We already have, but technology is getting better and better and better. You have to be careful with it. You have to pay attention to it. But if you use it appropriately, it can really help make your compliance program more efficient. It can help you save money, and it can help you, be able to show to regulators or enforcement agencies if they ever come knocking that you're really doing everything that you can to try to prevent that conduct. And then the last thing, of course, is engage with experts like Shafak and his firm, other people who are in the compliance space, who understand sanctions and export control and do it day in and day out. Talk to those people, pick their brains, understand what the issues are, and then apply that to your programs.
I want to ask you a technology-related issue, and what are some of the biggest challenges that organizations face when integrating the AI into their compliance programs? Because it's a long discussion that the AI is very commonly now in practice, and what are the biggest challenges of that?
Yeah, well, so first of all, I think it's important to say that compliance is and risk management, for that matter, is an art. It's not a science, right? And so there is always going to be some human factor when it comes to compliance, but you can use technological tools to increase your capability and efficiency to better improve your compliance program. AI, of course, can miss some of those intricacies. It is not another human being, but it is really good on picking up on information and data that you may miss in a huge data set. And so you want to sort of play off of each other and use the strength of your compliance team and your employees and your human capability, and pair it with your AI technology to make yourselves just better at your job. One thing that AI is improving on but still has problems with are names. And so, when you're talking about the sanctions space, in particular, economic sanctions under OFAC regulations, computerized screening can miss matches, particularly when it's not like a non-Latin alphabet involved, or when you've got very complicated company names or very similar company names. AI is pretty good now at filtering through that, but it's not perfect yet. And so that's something you'll want to double check every time with eyeballs. And that's important to know. But integrating AI into compliance presents several challenges. Here are a few of the biggest ones, but we could talk about this probably all day. One is data privacy and security, right? Because you are feeding information into a system. AI requires huge amounts of data to be able to run, and it requires training data. And so raising concerns about privacy under the GDPR, the CCPA, where is that information going? Who has access to it? What is it being used for? You'll want to understand on the back end of your AI program or provider, what are their security protocols, what can be used, and for what purpose. That's really, really important so that you don't get yourself in trouble in some other space trying to comply with sanctions. One problem is bias and fairness, right? AI, of course, is a machine, right? It doesn't have human emotion or thought processes. It is really taking data and processing data. And so it can inadvertently perpetuate or amplify biases from training data if you're feeding it the wrong information to begin with, junk in, junk out sort of scenario. So you'll want to make sure that you regularly audit your AI models and implement fairness awareness algorithms to make sure that what it is catching is appropriate and it's not flagging things that shouldn't be flagged. Of course, that's not what you want anyway. Regulatory compliance is important to keep in mind because the laws are changing so quickly and because designations are happening on such mass scale and because the US government and other governments for that are trying to sort of match pace with what the US already had in place. There's a lot of information coming out, not only in relation to the specific designations, but also in relation to, the types of guidance and tri-seal letters and other things that DOJ is putting out and the way that they want documents formatted and the way that they want information provided and the way they want it to be in a particular type of computer program, all the way through to the whistleblower programs and other issues. So there's a lot to keep up with. And so you'll want to be able to feed that into your AI models and keep up as you go. Transparency and explainability, right? Of course, any program that you're using, you'll want to be able to be able to talk about, to be able to explain clearly what information is going in, what information is coming out, how are we using that, and how reliable is it. Using explainable AI to make AI decision processes more transparent is going to help your business not only do a better job at catching sanctions violations, but it's also going to help you explain it to regulators and enforcement agencies. AI being built over your existing systems is also important. You have institutional data and knowledge and capability. AI is not meant to replace that, it's meant to enhance it. And so you'll want to keep that in mind when thinking about AI. And then the last and maybe the most important thing that we should talk about is AI is expensive. And so that's a huge challenge, to implement AI and to have AI technology and capability and to continue to maintain that capability up to standard and with the information being current cost a significant amount of money. But of course, in any compliance program, there has to be an investment. Compliance programs don't work unless you are investing in them and putting the money into them that make them function. That is true across technological platforms. It's true across employees and compliance personnel. It's true for AI. If you are going to be serious about analytics and AI in your compliance program and be on the front edge of compliance for your global business, then you have to be prepared, to invest in it and in the long term. And so that, of course, is not not every company can do that at this point. So looking for solutions where you can use AI on a limited basis, use it for a particular function and then grow and build into it. But it's a wonderful tool. We're using at our firm multiple AI platforms to help us perform our work, not only in our investigations practice, but also in our compliance for our clients. We are, bringing those tools to bear. And I have to say, I've been very impressed with it.
Mhm. And let's talk about AML. And what do you think about the AML compliance and what common pitfalls do organizations face and how they can avoid it?
Yeah, so AML and sanctions are popping up together more and more. You'll see historically, for example, in the U.S., if you were charged criminally with a violation of sanctions, you are also almost guaranteed to be charged with a violation of the anti-money laundering laws in the U.S. They are two vastly different laws with very different requirements, but they almost always overlap because of the way that the government views sanctions and the transactions that occur. They shoehorn those into anti-money laundering, and there have actually been instances where companies have, they've beaten the sanctions charge, but they are convicted on the anti-money laundering charge. And so there are key challenges related to anti-money laundering. Anti-money laundering is really the facilitation of a transaction where the proceeds of that transaction are from illegal conduct or the proceeds further illegal conduct. And so you can imagine that because the US government views sanctions evasion or violations as criminal under IEPA, that transaction coming across the wires to the US bank, then by virtue of being illegal at its inception is also a violation of the anti-money laundering laws. We could talk a lot about anti-money laundering separately, but here are the things you need to keep in mind. The biggest problem with your anti-money laundering program is an inadequate customer due diligence. You know, you have to be able at your businesses to be able to bring in customers and vet them. And that's true across every type of compliance, whether it's anti-money laundering, sanctions, anti-corruption. You have to know who you're dealing with. That is your biggest source of risk, because if they come in and everything looks good, even if they're not telling you the whole truth, which happens in almost every instance, and you are facilitating illegal payments for terrorist financing, for illegal behavior around the world, that is an anti-money laundering breach. And so you have to be able to implement those customer due diligence, KYC, know your customer type protocols to verify client identities, assess their risk, conduct ongoing monitoring about them, and ultimately make a decision about whether you want them to be your customer or not, right? I think the same is true really for suppliers, but for anti-money laundering, it's really on the front end customer side that you've got the biggest problems. The second is really an insufficient risk assessment. You want to know what you're doing as a company, who you're selling to, what you're selling, and to understand where the potential issues might be. A lot of companies don't sit down and spend the time thinking about that in a real way. They assume their customers are doing the right thing, and I mean that in some instances would be reasonable to assume, but in the world we live in, for any global company, you have to be able to identify where your risks are, and I think insufficient risk assessment on the front end causes tons of problems on the back end. Lack of regular training. I mean, that goes without saying. If your compliance team, if your employees, if your management does not know what anti-money laundering is, they're never going to be able to catch it. What I will say about anti-money laundering schemes is they are very complicated, and they are often pretty hard to run down. It's you're looking for clues that lead you to more information, and you have to be really attuned to those kinds of things to be able to spot an anti-money laundering scheme running through your company. And so training employees to identify those and raise them to the appropriate level who has the experience to investigate further is critically important. Weak internal controls obviously is always a problem. Make sure that you establish, internal controls about this stuff. Make it clear that, certain types of transactions are not permitted, period, full stop. Same with policies and procedures, make sure that those are updated and following current trends. Make sure that your employees are reporting this conduct, right? Make sure that there's an opportunity for them to report internally. This is even more important based on what I said earlier with a new whistleblower reward program, is you want to incentivize people to report misconduct to you first and early so that you can take care of it in-house without worrying about, some regulator or enforcement prosecutor, FBI agent, whoever coming to your door first. And then finally, again, I'll hit this one again, but the biggest problem with AML compliance is not having AML compliance because of budget limitations or inadequate resources. All of these things require manpower. They require people to sit down and think about it, to write the policies, to follow the policies, to do the investigation. And so invest in a program of anti-money laundering so that you can catch them before they become a bigger problem.
Mhm. And you mentioned about the whistleblower laws, the recent developments in the US. So the question is, how should organizations adjust their compliance policies and internet reporting mechanisms to align with these new laws?
Yeah. The first thing, obviously, that you want to do, and I've said it a couple of times during this presentation, is you want your employees to come to you first. To the extent that you can incentivize that appropriately and within the laws of your country, you will want to make sure that they have every tool available to them to come to you first so that you can solve the problem internally. What you do with that information after the fact, you may decide under the reporting requirements to self-disclose that to the government in hopes of having a non-prosecution, a limited fine to mitigate the potential downside outcome of that. But you want the employees to come to you first. And so it's really a race against the clock, right? Once an employee reports the conduct outside of your company, then certain things happen. One is that you have from the date that they make that report and you're notified about it, you have 120 days to investigate and then make a decision about self-reporting. If you do that within the 120 days, it's a safe harbor, meaning that under U.S. policy currently with the Department of Justice, if you self-report certain conduct under their guidance, you will get and be entitled to a non-prosecution agreement, meaning that you will not be prosecuted. There will be, leniency related to any potential fine or outcome of the case. And that, of course, always, inures to your benefit. What you don't want is to sit on information, the government finds out about it, and then they find out that you've been holding that information. That's always much, much worse. So that race to the clock, that 120 days you then have to report, means that you have to have investigations protocol in place, meaning that should already be worked out. What do we do with this information? Who gets it? Who does the investigation? What kind of reporting are we going to get? And what do we do with it after the fact, which may also require a voluntary self-disclosure policy and procedure. So what we would suggest in every instance is in your compliance program to have, of course, all of the whistleblower hotline, the anonymous email, the ability to have a platform by which they can get the information to the people who can do something about it. But also for your compliance team to have a designated set of rules and protocols on what to do with that information once you get it. In some instances that will require outside counsel. In some instances, it will not. For most of the things that you were getting whistleblower complaints about, they were going to be a significant enough severity and concern that you are going to want to consult outside help. And that does, a couple of things. One, if it does become, apparent that you need to self-disclose it, the investigating firm or consultant will be able to guide you in doing that to make sure that it is put in a proper format and makes the best case possible for you and your company. The other thing that we'll do is show the government that you were serious about this from the outset, that you put the resources, time, attention, and brought in outside assistance to deal with this problem. That will go a long way in their minds about, you know, how seriously you took this, and they weigh that very heavily. The other thing that companies are going to want to pay attention to under these whistleblowing protocols, particularly in the US, of course, there's the EU whistleblower protocol, which is very stringent and very good. And so you obviously want to pay attention to that too. But as it relates to the US, there's the anti-retaliation section, meaning that if a person reports outside, you cannot take adverse employment action against them. It would be bad news, for example, if you learned that someone reported to the government and then you turned around and fired that person because of the report. And so making sure that you have procedures and policies in place against anti-discrimination or anti-retaliation for those individuals who do choose, if they happen to go and report it outside your company. But I think the biggest takeaway here is three things. Make sure that you have, to the extent possible, your employees in a position where they can report to you and feel safe and incentivized to do so. Once you get that information, make sure you are investigating it and running it to the ground so that you have the information and make decisions quickly about what to do with it. And the third is make sure that those employees are not treated unfairly by retaliating against them or causing them to be discouraged from reporting misconduct to the company that they think is going on.
Thank you, Brett. Thank you for these insightful remarks. And if there is any questions, we will be happy to answer your questions. Please leave your questions on the Q&A box. And if it seems that there will be no questions, I have typed it in the Q&A box, but there is nothing dropped yet. And I would like to thank everyone for joining us today. And thank you, Brett, once again, for your valuable insights. Hope we will have another webinar on the sanctions issues in the coming days. Thank you very much.
Thank you, Shafik. Thanks, everyone.